This will be the final presentation that I'll be giving for today, not counting the Q&A that we'll be having. And this will last until, let's see, it's 5 to 1, so are we going till, what, 2:55? Or 1:55, I guess I meant to say. Math was never my strong point. But anyway, I know that I'm covered with more clothespins than I can comfortably carry, but I understand they're given in fun and gesture, so I need to have a couple pictures of this to take back to my office. They would never believe that anybody would like me. But we're going to be talking about new directions in religious liberty. And one new direction in religious liberty took place about 3,500 years ago, and that's when you see separation of church and state in the proper sense being instituted in Israel. You recall that in Israel, unlike the nations around it that practiced state worship and emperor worship, but in Israel you find that the kings come out of the tribe of Judah, the priests come out of the tribe of Levi. Separate offices, separate functions, but both are under the authority of God, both are instituted by God, and both are subject to the law of God. And you can see where this is reinstituted as you get to 2 Chronicles 19, when there has been a period of apostasy in Israel, and Jehoshaphat is trying to restore things to the way they should be. He reestablishes the judges, and he says to the judges, "Take heed what ye do, for ye judge not for man, but for the Lord who is with you in judgment." But then he restates the separation of authority in verse 11, "And behold, Amariah the chief priest is over you in all matters of the Lord, and Zebediah the son of Ishmael, the ruler of the house of Judah, for all the king's matters." So again, we see this separation. We see other forms of separation in the Old Testament where Saul, when he waits for Samuel and Samuel doesn't arrive on time, so Saul goes ahead and offers sacrifices himself, which was usurping the function of the priesthood. And for this, his line is cut off from the kingship of Israel forever. He isn't removed, but his posterity never get to serve as kings. And then we have Uzziah. King Uzziah goes into the temple, begins to offer sacrifices in the temple, and what happens to him in 2 Chronicles 26? He is what? Smitten with leprosy. And I would suspect that for the rest of his life, every time he looked at his hand there, he thought, pardon the Alabama expression, but keep your cotton-picking hands off the church. And we can go to the New Testament. There in the New Testament, you recall that the Pharisees came to Jesus and they thought they had a question that they could trap him with. So they asked him, "Is it lawful to pay taxes to Caesar or no?" And they think if he answers yes to this question, his popularity in the next Jerusalem poll is going to be down about 90 points. If he answers no, they'll immediately go and tattle to the Romans and he'll be arrested, and either way, they've got him. But instead, Jesus gives an answer that isn't a direct answer to the question. When you're the Son of God, you don't have to answer questions directly. And he says, "Show me a coin. Whose image is this? Caesar's." And I could preach a whole different message about that, because the Jews did not believe in graven images, and so they would not use coins if they had inscriptions of gods on them. And so they had Roman governors of Judea had a special dispensation from Caesar that they could produce coins with Caesar's image alone without the superstitious inscriptions that would others use. But Jesus asked, "Whose image is this? Caesar's. Render therefore unto Caesar the things that are Caesar's, and unto God the things that are God's." And when Lord Acton looks at that passage in the later 1800s, he says that Jesus, in this statement, gave to the state a legitimacy it had not before realized that its power came not just from pagan gods, but from the Almighty God himself. But secondly, that Jesus placed a limit upon government, that there were areas that were outside government's jurisdiction. And Acton said, keeping the state within its appointed limits became the perpetual responsibility of the church. And so, Old and New Testament alike, we see this concept of separation. And that concept continues. As we go through the Middle Ages, we see a separation there, even within the Roman Catholic Church, and we see church and state interfering with each other in ways that were sometimes not appropriate. But we don't see popes becoming kings, and we don't see kings becoming popes. That's until we get to Henry VIII in England, when he decides to pull England out of the Roman Catholic Church and make it the Church of England with himself as the head. And when you see many of the settlers who came to this country for religious freedom, that's what they were getting away from. An official state church with the king as the head. Pilgrims, Puritans, they didn't come here to get away from prayer at football games. They came because there was an established church in the real sense of establishment. But throughout the Middle Ages, there is a belief of the Roman Catholic Church that, yes, God has established these two institutions, church and state, but the church is the superior of these two institutions. Because, first of all, the state gets its authority through the church, from God, but through the church. And that's why many times in medieval societies, when a new king was crowned, they would want a pope or a cardinal or an archbishop to crown him, to understand that he was getting his authority from God, but getting it through the church. Then as we move into the Reformation period, we have a view that is dramatically opposite that of the Catholic Church, and that is the Anabaptist view. And when I say Anabaptist, I'm not talking about modern Baptists today who, in their view of church-state relations, will be more like Lutherans and Catholics, but the extreme Anabaptist view was that the church came from God, the state either came from Satan or else Satan took it over, and therefore the state is like an enemy kingdom. And as Christians, we should pay taxes and we should obey the law, but beyond that, we should have as little to do with government as possible. We shouldn't serve in the military, we shouldn't hold public office, we shouldn't vote, we shouldn't do anything except those two basic responsibilities. But in between that, we have the views of Luther and Calvin that are very similar. And essentially what they say is that God has established two kingdoms, the church and the state, and neither is over the other. Rather, each has its own domain, and God has established each for a reason. He's established the church to preach the word of God and administer the sacraments. He's established the state to keep law and order on the streets, to keep enemies off our shores, to protect human rights. But I suggest to you that many times the problems we have in society today, especially here in America, is that we expect the state to do what should be the work of the church, and we expect the church to do what should be the work of the state. Well, we've talked about the medieval view, Luther and Calvin. Their views are similar. There would be a few differences. One of the differences would be that Luther would see the role of the state as protecting the church. Calvin would go a little further and see the role of the state as actively promoting the church, especially some Calvinist thinkers like Althusius with his work Politica, which is very much worth reading. And also, you would probably find that Calvinists, as far as their application to society, would be more likely to apply more or less literally Old Testament law. We look to the early American New England colonies, and we find that many times in those New England colonies, when they drafted a law code, the law code would be essentially a restating of the book of Deuteronomy. And frequently, the one who would do the drafting of the code would be a clergyman who may have had some legal training. But as we move from the colonies toward American independence and then the American Constitution, if we go in time from Jamestown of 1607 all the way to 1789, we're talking about a space there of 182 years. We tend today to put all of that into one category. The whole colonial experience, everybody was alike. No, they were different in the various colonies. In the New England colonies, you have the Puritan church established, with the exception of Rhode Island. In the southern colonies, Alabama, it's kind of hard for me to think of Virginia as being southern, but the southern colonies of Virginia, the Carolinas, and Georgias, the Church of England, the Episcopal Church is established. And then in the middle colonies, colonies like Rhode Island and Delaware and New Jersey and Maryland, Pennsylvania, also New York, you sometimes see a greater degree of religious freedom than in the North or the South. But even in these colonies, you see usually requirements that if you're to hold public office, you must recognize God, and that in order to vote in Pennsylvania, you had to affirm the Trinity and so on, sometimes affirm the authority of Scripture. But that's the experience of the American colonies. So what changed in those 182 years between 1607 and 1789? Why do you see in 1789, now we have thinkers starting to talk about no establishment of religion, when establishment of religion was exactly what they were trying to get before? Part of this was Puritan thinkers like John Bunyan with Pilgrim's Progress, or John Milton with Paradise Lost. Milton was also on the cabinet of Oliver Cromwell when he ruled England, but they were believers in religious liberty. Now, they didn't want to extend religious liberty as far as atheists, that they were entitled to no liberty at all, because that wasn't really a religion as they saw it, and so no protection for atheism. Another thing taking place during this time is the European so-called Enlightenment, and depending on how you define the Enlightenment, you could define it broadly enough to include even the Protestant Reformation as part of the Enlightenment, but we're talking here more about French thinkers like Voltaire and Rousseau and others, and these had some influence, but they could talk a good fight about religious liberty, but they're not the ones that are out there fighting for it. The ones that are actually putting their heads on the chopping block for religious liberty are people like sometimes Baptists, sometimes Roman Catholics, sometimes Puritans. They're the ones that are really ready to stand for religious liberty. And then we find in the later 1700s, we find people like Patrick Henry, James Madison, and others that are actively defending those who are in jail for preaching without license from the Church of England. Madison describes how as a young boy he'd come home from school and he'd go past the jail, and he would hear Baptists preaching in the jail. And he said, it always amazed me that they were jailed just for preaching, especially when their preaching was in the main quite orthodox. Interesting, he knew what orthodoxy was and thought that was important. Anyway, those are a few things. Another major factor that led to religious liberty was the Great Awakening, the religious revival of the 1740s. Awakening that was led by Jonathan Edwards, George Whitefield, William Tennant, and others. But Whitefield in particular would travel this country. He came over from England by way of Ireland, and it said that he could preach to a crowd of up to 20,000, 30,000 people without a microphone, and that he could cause people to tear up in their eyes just by pronouncing the word Mesopotamia. Let me try it. Mesopotamia. No, I'm getting laughter. Nobody's crying. I don't have that touch, I guess. But all throughout the colonies, you have people like Whitefield preaching all the way from New Hampshire down to Georgia, preaching essentially the same message. People are getting saved by the hundreds of thousands, and more than that, rededicating their lives to Jesus Christ. And then you start having a lot of people who are thinking, Okay, we are now with dissenting churches. We are now Baptists or Lutherans or Presbyterians or Methodists. So why should we be paying taxes to support the Church of England? Especially when we're not all that convinced that the Church of England is that spiritual a church anyway. And so now the Baptists and the Presbyterians and the like are finding that if they can combine their numbers, they can outvote the Church of England people. And so we see the Church of England being disestablished sometimes. In 1776, for example, South Carolina adopts a new constitution. And in the new constitution, well, the old constitution provided a tax that was to go to the support of all Church of England pastors. The new constitution, it said that the tax support will go to all Christian Protestant pastors. I don't hear the American Civil Liberties Union jumping for joy at that, but it was quite a step from what they had earlier. But one of the main things that caused the colonists to start to think differently about religious liberty issues was now that we've gone beyond the Articles of Confederation, now that we have a new constitution that creates a true federal government that has a lot more power than we simply had under those Articles of Confederation. So now what's going to be the official religion of the United States? We have our state churches here in the South, the Church of England. We have the Puritan churches in the North. What's going to be the official religion of the United States? And up north, they're saying, we certainly don't want it to be the Church of England. We came all the way across the ocean to get away from those heretics. And in the South, they're saying, and we don't want it to be the Puritans. All those strict things that they do up there in Massachusetts and New Hampshire, we don't want to have to do that down here. And a lot of people were afraid of the Quakers in Pennsylvania because Philadelphia was the first capital, and Quakers not believing in military service, what would that do to our defense? Everybody was afraid of the Catholics in Maryland, and the Baptists of Rhode Island were afraid of everybody. And so they came to a conclusion that at the federal level, with this new constitution, we should have no establishment of religion. And so the Constitution read, with that First Amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. But, as I'm sure you've been taught well on this, that when you hear phrases like that, you have to ask, what does this mean? What does it mean, no establishment of religion? Well, there are essentially two views that the courts have taken about what is an establishment of religion. One is what we call the separationist view. And the separationist view was that church and state are to be as separate and distinct from one another as possible. And usually those who advocate the separationist approach will cite Thomas Jefferson. Thomas Jefferson, I believe it was 1801, when he wrote a letter to the Danbury Baptists in which he used that phrase, wall of separation between church and state. And essentially, that has been greatly distorted, as Dr. Driesbach has pointed out in his book, and as Dr. Schultz mentioned last night. But essentially, what Jefferson was saying to the Danbury Baptists was, you have nothing to fear from this new federal government because there is a wall of separation that protects you from them. Today, we don't usually use that phrase, wall of separation, to protect the church from the state. Usually that's been inverted, and it's inverted to protect the state from the church. It began to be perverted in that way back in 1947 with the case that Dr. Schultz was mentioning last night, Everson versus Board of Education, which the court said we cannot tolerate the slightest breach. But they did say that since the state has an interest in making sure that kids get to school, whatever school they go to, that it's all right to bus school children to Catholic schools because we want them to get an education no matter what. And the purpose of this is public safety and ensuring that education takes place. So Justice Black, in that opinion, said that New Jersey has not breached the wall of separation here. But when we looked at that phrase, that, with the Everson case, pretty much became the standard way of interpreting the First Amendment. In fact, it's probably fair to say that from 1947 up until at least the last decade or so, more people were familiar with the phrase separation of church and state than the actual language of the First Amendment. And in fact, I have law students that are amazed to find that that phrase separation of church and state is not in the Constitution. But that's one interpretation that the court has used to produce sometimes some very radical policies of treating religion unfairly, in the sense that religion does not get equal treatment with other forms of thought, but rather discriminated against and prohibited in the public arena. But that's one way of interpreting it. Another way is what we call the accommodationist view, or sometimes that's called the non-preferentialist view. Madison seemed to hold that view. Boy, it would sure be nice to have a transcript of the debates of the First Congress. We don't have it. All we have is notes, and Floyd's summary, his notes from that Congress, say that Madison was asked what was meant by that term establishment of religion, and his summary simply says, Mr. Madison said he apprehended the meaning of the words to be that Congress should not establish a religion and enforce the legal observation of it by law, nor compel men to worship in any manner contrary to their conscience. Anyway, so Madison doesn't seem to say that you have to have an absolute separation, but just that you can't enforce a particular religion by law, and you can't make people worship contrary to their conscience. Chief Justice John Jay, whom I mentioned last night, and John Jay was, as I said, president of the American Bible Society, but Justice Jay, back at that time, the first decade of the Supreme Court, the 1890s, at this time, there was no Supreme Court building. At this time, the court would meet in the courtrooms of the various states. And on one occasion, they were to meet in the chambers of the Supreme Court of the state of Massachusetts. And there in Massachusetts, some of the court officials are wondering what should we do with the Supreme Court justices coming. And so they asked, do you want robes? Shall we furnish robes? Are the ones that our justices use okay for you? What kind of accommodations would you want? Anything special we should do for the courtroom and so on? And then they go on to say, in New England, we have a practice that at the beginning of every court term, a pastor comes in and opens in prayer. Would you like us to do that? Chief Justice John Jay writes back, and he says, all of these accommodations and suggestions you make, they are fine with us. Whatever you've been doing before, keep on doing. Then he says, the practice of having a pastor open the court with prayer should be observed and continued. He is very explicit about that. Question sometimes arises, and it arose during the Ten Commandments battle in Alabama, and I was pleased to serve on the Ten Commandments legal defense team along with Judge Moore and the others on that team, and not too long after that, the Foundation for Moral Law was formed, and so for the last 16 years, I've been serving as senile counsel for the Foundation for Moral Law. But anyway, one of the issues that came up, the other side was saying, it's all right for Judge Moore as an individual to acknowledge God, but he can't do so in his official capacity as a judge of an Alabama court. Is that really what the First Amendment means? Well, George Washington didn't seem to think so, and he chaired the Constitutional Convention, and he was president while the Bill of Rights was being considered. And he, on the 3rd of October, 1789, issued a National Day of Thanksgiving proclamation in which he said, whereas it is the duty of all nations to acknowledge the providence of Almighty God. Not just the duty of individuals, but the duty of all nations. President Lincoln in 1863 issued a proclamation appointing a national fast day. And in that proclamation, he says, and he makes it even more clear than Washington had, it is the duty of nations as well as of men to own their dependence upon the overruling power of God. So very clearly, the thinking of Washington, and for some time afterward, was that the nation as an institution and public officials in their official capacities may acknowledge God. Well, the question that I have to ask is, who understood the intent of the framers of the First Amendment better? George Washington and Abraham Lincoln, or Judge Myron Thompson in that Alabama court? I would like to believe that Washington did. Back in 1853, there was an issue that came up concerning military chaplains and congressional chaplains, and so the Senate Judiciary Committee and the House Judiciary Committee both did extensive studies on the meaning of the First Amendment, and both concluded that military chaplains and congressional chaplains did not violate that amendment. And the reports are very similar. I'm just going to read a portion of the Senate's report. The clause speaks of an establishment of religion. What is meant by that expression? It referred without doubt to that establishment which existed in the mother country. Its meaning is to be ascertained by ascertaining what that establishment was. It was connecting the state with a particular religious society by its endowment at public expense, in exclusion of or in preference to any other, by giving its members exclusive political rights, and by compelling the attendance of those who rejected its communion upon its worship or religious observances. These particulars constitute that union of church and state of which our ancestors were so justly jealous and against which they so wisely and carefully provided. Our fathers were true lovers of liberty and utterly opposed to any constraint upon the rights of conscience. They intended by the First Amendment to prohibit an establishment of religion such as the English church presented, or anything like it. But they had no fear or jealousy of religion itself, nor do they wish to see us an irreligious people. They did not intend to prohibit a just expression of religious devotion by the legislators of the nation, even in their public character as legislators. They did not intend to send our armies and navies forth to do battle for their country without any national recognition of that God upon whom success or failure depends. They did not intend to spread over the public authorities and the whole public action of the nation the dead and revolting spectacle of atheistical apathy. Not so had the battles of the Revolution been fought and the deliberations of the Revolutionary Congress conducted. On the contrary, all had been done with a continual appeal to the supreme ruler of the world and an habitual reliance upon his protection of the righteous cause which they commended to his care. Those things certainly give us an idea as to what the framers meant when they used that word, establishment of religion. Well, the Supreme Court has tried to deal with that in quite a number of ways, and there's a famous case, 1971, Lemon versus Kurtzman. It involved government aid to private schools, and in this case, the court said that anytime government is involved with public schools, or anytime government is giving aid to any kind of religious endeavor at all, that aid is going to be unconstitutional unless it satisfies all three prongs of a three-prong test. We call this the Lemon test, and some of us think the test was well named. But the test was this. First, the statute must have a secular purpose. Second, the primary effect of this statute must not be to either advance or inhibit religion. And third, it must not constitute or foster excessive entanglement of government with religion. Now, within that, you can see where there is a little leeway for judges to decide what's excessive and what is a primary effect and so on. I get into a lot of radio debates, television debates, things like that, and I usually enjoy those, and usually they're rather dignified and You say things like, well, I respectfully disagree with what my esteemed opponent has just said, that sort of thing. On one occasion, though, I was in a debate with a radio station in the Kansas City area. It was over prayer at football games, and my opponent was an ACLU lawyer. And this time, we'd kind of taken the gloves off, and we were both being a little rude to each other, and I haven't had that much fun in a debate since. But anyway, he starts talking about the Lemon Test. He said, when you have cases involving establishment of religion, the courts use the Lemon Test. He talks about this as though an Alabama hillbilly wouldn't know what it was. But number one, it has to have a secular purpose. It can't have any religious purpose. Number two, it can't have any effect of advancing religion. And number three, there can't be any entanglement of government with religion. Well, when it was my turn to respond, normally I wouldn't say this in a debate, but I just said that I've been teaching the Lemon Test to my students in the law school for decades, but I've never had a student flunk all three prongs of the Lemon Test like the ACLU attorney just did. First of all, it says that the statute must have a secular purpose. It doesn't say that has to be the only purpose. It doesn't even say that has to be the main purpose. And it certainly doesn't say it can't have a religious purpose as well. Secondly, it says that the primary effect must not be to establish or inhibit religion. It doesn't say that it can't have any effect of advancing or inhibiting religion. And by the way, Mr. ACLU attorney, you left out the part about inhibiting. And third, it doesn't say it can't have any entanglement with religion. It simply says that the entanglement cannot be excessive. And so there's a lot of leeway there, and a good example of that is a case that took place in the early 1990s, a case, the Lamb's Chapel, which was a church, versus Center Mauritius Union Free School District, and Lamb's Chapel wanted to rent the school auditorium in order to show a James Dobson film. And the school said, no, you can't do it because that would be violating the Establishment Clause. That would be a union of church and state. We can't have that. Well, Lamb's Chapel filed a lawsuit. It went to the Supreme Court, and the Supreme Court ruled in favor of Lamb's Chapel. They said that this doesn't violate the Lemon Test. First of all, there is a secular purpose. The secular purpose is to allow outside organizations to have a place where they can meet. And secondly, it means the church or the school gets in some revenue by renting its auditorium to people when the school isn't using it. And as far as the effect of advancing religion, well, when we look at this overall policy of renting the school auditorium to many secular organizations and to religious organizations as well, but many different denominations of religious organizations, we can't say that the primary effect of renting the auditorium is to establish religion. And the only entanglement we see here is that, first of all, the school takes the rent check, and then it has to make sure the custodian is there to unlock the door and make sure that the air conditioner is running. We don't think that's excessive. But Justice Scalia, for many of us, we'd probably consider Justice Scalia to have been maybe our favorite justice on the court, and he could write so sardonically sometime and such a sense of humor that he would put it in his opinions. And I'm going to just tell you what he says in a concurring opinion. He says, yes, I agree, this doesn't violate the Lemon Test, but I think we should go further, and I think we should throw out this stupid Lemon Test entirely. Here's what he says, and usually when I was teaching, I got to teach this case right about Halloween. But here's what he said. Like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad, after being repeatedly killed and buried, Lemon stalks our Establishment Clause jurisprudence once again, frightening the little children and school attorneys for Center Mauritius Union Free School District. You don't believe that Supreme Court justices have a sense of humor? Its most recent burial, to be sure, was not fully 6 feet under. Our decision in Lee versus Weissman conspicuously avoided using the supposed, quote, test, unquote, but also declined the invitation to repudiate it. Over the years, however, no fewer than 5 of the currently sitting justices have, in their own opinions, personally driven pencils through the creature's heart. The secret of the lemon test's survival, I think, is that it is so easy to kill. It is there to scare us and our audience when we wish it to do so, but we can command it to return to its tomb at will. When we wish to strike down a practice it forbids, we invoke it. When we wish to uphold a practice it forbids, we ignore it. Sometimes we take a middle course, calling its three prongs no more than helpful signposts. Such a docile and useful monster is worth keeping around, at least in a somnolent state. Never knows when one might need him. But the majority opinion always gets the last word. And so the author of the majority opinion has a footnote. And in his footnote he says, "While we are somewhat intrigued by Justice Scalia's evening at the cinema, we return to the reality that there is a proper way to inter an established decision. And Lemon, however frightening it might be to some, has not been overruled." But the court was gradually pulling away from the Lemon test for quite a long time. And one case in which they ignored the Lemon test entirely was around 1983, the case of Marsh versus Chambers. Marsh versus Chambers involved the state of Nebraska. Now, when you look to the legislative branch of government, there is one thing that is unique about Nebraska. Anybody know what that is? Unicameral. They have only one house. Every other state has two houses, and some states Congress required them to, but Nebraska has a one-house legislature. And this house had employed a Presbyterian pastor to serve as their chaplain, and he was paid a small stipend each month for opening each legislative day with the word of prayer, and then being available to counsel legislators if any of them needed counseling on something. And Senator Ernest Chambers, a very liberal senator in Nebraska from the Omaha area, challenged this, saying that this is an establishment of religion. Look, here's a pastor. You're paying him with money by the state to conduct prayer during during legislative services. That's establishment of religion. But the Supreme Court disagreed. And the Supreme Court said that's not an establishment of religion. Rather, the Supreme Court said that when you look to what the First Amendment actually means, you have to go back to look to how it was applied at the time. And they said, look back to the American colonies. The colonies had chaplains for their legislatures. Look to Congress. At the same time that Congress adopted the First Amendment, just a couple of weeks later, they established a committee to establish congressional chaplains. James Madison, primary author of the First Amendment, in fact, voted for that resolution to establish congressional chaplains. And so, clearly, when you have a practice, the court says, that predates the Constitution, and when there is no evidence that the framers of the First Amendment intended to change that practice isn't forbidden, it's kind of grandfathered in and sanctioned. And so, the Supreme Court said that having congressional chaplains like this does not violate the First Amendment. It was only a 5-4 decision. Anyway, so for quite some time, from the 80s up into the early 2020s, we had the court seemingly adrift on how to handle the Establishment Clause, and whether something would get approved or disapproved by the Supreme Court really depended more on who had a majority on the court at the time. And that's one of the reasons why so many of these First Amendment decisions for those years were 5-4 decisions, either 5-4 striking something down or 5-4 upholding it. Possibly the worst decision under the Establishment Clause ever decided was Stone versus Graham, involving Kentucky public schools in 1980. In this case, the Supreme Court said that a Kentucky statute that required that the 10 Commandments be posted in public school classrooms across the state, that this violated the Establishment Clause. And it was a 5-4 decision. 4 justices thought there was no violation at all, but the 5 that said it was a violation, they said that What would be the purpose of having those 10 commandments? It could be religious. Students might read the 10 commandments there, and they might be inspired to venerate or obey those commandments. There's no secular purpose in telling kids that they shouldn't murder or shouldn't steal. It's a crazy decision. And I can almost assure you that if that case came before the Supreme Court today, it would come with a very different result. But anyway, the big changes that we have seen have been within the last several years. We at the Foundation have been involved in every one of these cases the last several years, filing what we call friend of the court or amicus briefs. And first of these was in 2018, the American Legion versus the American Humanist Association. Right after World War I, about 1920, Bladensburg in Maryland established about a 34-foot-high cross right on a public highway to commemorate soldiers from that area who had died in World War I. And the American Legion was involved because they had been caring for this monument as a tribute to veterans. But then, as we move into about 2015, the American Humanist Association files a lawsuit saying that this cross on public property is in violation of the Establishment Clause and it needs to be taken down. Well, we filed an amicus brief and we pointed out, first of all, that there has been a tradition of erecting crosses in public places going way, way back before America was founded, that Christopher Columbus, when he landed, that one of the first things he did was to plant a cross and have a worship service. By the way, some of you may not understand what it was why Columbus actually treaded water out there with his ships for 3 days before he landed until October 12th. Anybody know why he did that? It was because he wanted to land on Columbus Day. Post hoc ego pro hoc, I guess I have my cause and effect turned around there, don't I? The Jamestown settlers in 1611, when they landed, they planted crosses. In the western part of America, you find that when the Spanish conquistadors and other Spanish explorers came, they would plant a cross. It was to claim this particular territory both for Spain and for Christ, which they saw as pretty much identical. So the idea of planting crosses has a tradition in the United States. Secondly, we argued that it has a special military tradition. You go to our U.S. cemeteries overseas, you see row upon row of crosses. If you go to Arlington here, you'll find that in the older section, there are all sorts of crosses, Celtic crosses, Jerusalem crosses, Latin crosses, all sorts of crosses there. In the newer section, they all have to be uniform, but on the gravestone itself, you will see an emblem, and it can be a cross or a Jewish symbol. The vast majority of them are crosses. And so there's an identification of the cross with the military. In fact, next to the Congressional Medal of Honor, the highest medal you can get in the military is the Distinguished Service Cross in the Army, or the Navy Cross, or the Air Force Cross. But think about this. Jesus said, "Greater love hath no man than this, that he lay down his life for his friends." The cross has been a symbol of sacrifice. Anyway, the Supreme Court, by, I believe it was a 6-3 margin, voted in that case that the Bladensburg Cross was not an establishment of religion. And I don't know where they got all their reasoning for this, but much of what they wrote was very similar to the things we've said in our brief. I can't say that they got it from, what am I saying? Of course they got it from our brief, no question about it. But, no, we don't know. But anyway, so that is one major step toward getting rid of Lemon versus Kurtzman. I didn't say this in the brief. I was tempted to, I didn't say it. But I did say it in a press conference afterward, that actually the American Civil Liberties Union, the American Humanist Association, really wanted to get rid of the Bladensburg Cross so they could replace it with a 30-foot statue of Count Dracula. Because Dracula, like all vampires, recoils at the sight of the cross. Some of you aren't sure whether I'm joking or not. Well, then comes 2022. And in 2022, we have a couple of cases that are very important. One of these is Shurtleff versus City of Boston. Shurtleff is a very fine pastor there. He and I have become friends in the time since the decision was made. But Pastor Shurtleff would hold a camp in the city park in Boston. It was called Constitution Camp. And kids would come to this camp, kids, young adults, and so on. They'd teach on the Constitution and the Christian foundations of the Constitution. But one of the things they would do while camp was taking place is they would fly the church flag from the city flagpole. And the city said, nope, we're not going to let you do that. Now, at first, it sounds like what could be more an establishment of religion than flying a church flag, which has a cross on it, from a city flagpole? Until you consider this. It had been the practice of the city from time immemorial that any organization that was having an event in the city park could fly the flag of their organization while that event was taking place. Hundreds of organizations had been flying their flags during this time, including gay rights organizations, gay pride organizations, including organizations associated with the Chinese Communist Party. But now, here in Boston, the land of the Puritans, we're singling out the church of Pastor Shurtleff, saying that you may not fly your flag because it is religious. And we argued that clearly is discrimination against religion. Now, we would agree the city doesn't have to let anybody fly a flag. But if they're going to allow some organizations to fly flags during their events, they can't discriminate against a church simply because they are religious. That is discrimination against religion, not only in violation of the Free Exercise Clause, but also in violation of the Free Speech Clause. I'm not going to go into all this right now, but it's what we call viewpoint discrimination. Anyway, the Supreme Court unanimously agreed and said that this is an unconstitutional violation of free speech, and if you're going to allow other organizations to fly their flags, you cannot discriminate against Pastor Shurtleff and his church. Well, there was another case going on at this time, the Coach Kennedy case, which probably some of you have heard about. We also filed in that case, and that was decided a couple weeks later. But when I saw the Shurtleff ruling, I thought, well, I'm pretty sure Coach Kennedy's case is going to be decided favorably too. Coach Kennedy had a practice in the Bremerton School District out in Washington State that after each game, he would go out at first alone on the 50-yard line, and he would kneel and pray. And that went on for a while, and then some of his team members asked him, well, can we come out and kneel and pray with you? And he said, it's a free country, you can do whatever you want. And so a number of them did. Then some people on the opposing team would come out and join them in prayer too. And finally, the Bremerton School District decided, we can't allow this. Coach Kennedy, you're going to have to stop. He refused. He says, I must obey God rather than man. And so he was fired. Again, the case went to the Supreme Court, and the Supreme Court in this case ruled in favor of Coach Kennedy, and in this case, they officially announced that the Lemon Test was overruled, and the Lemon Test is not to be used anymore. It was a very good ruling. It was based to a great extent upon the earlier Shurtleff decision and on the earlier American Legion decision, but the court said that, look, if Coach Kennedy had come out and just told jokes, or if he'd come out just to give a team spirit address or something about good sportsmanship, or if he had come out and just quoted Shakespeare or something, you'd have no problem with that. but you have shut him down because he was praying. That is discrimination against religion. You could have a policy that nobody can come out on the football field to do anything or say anything. But if you allow some people, you cannot discriminate against Coach Kennedy because the content of his speech is religious. I will only add this to what I've said so far, and I know I need to close in about a minute here. I'll just add that what the court has been doing here is they've moved from what I would call a hostility toward religion, saying that religion has to be singled out for exclusion in the public arena, or for exclusion from aid when we're giving aid to all sorts of other organizations. They've moved from that to what they are trying to make as a position of neutrality, that religion has to be given equal treatment with other forms of expression or other organizations. I'm saying that doesn't go far enough. The position that religion plays under the Constitution is not simply one of being equal with others. It is a favored position. You don't see anything about free exercise of shopping or free exercise of political discourse or free exercise of sports or anything like that. Rather, you see singled out free exercise of religion. In other words, religion is given a preferred place in the Constitution, not simply an equal place. And my hope was that with 5 moderately conservative justices of the court and one more, Justice Roberts, who I will still say is a moderate conservative, my hope is that in the next few years, the court is going to move further and further in that direction. I think I close at 12, or was it 1:45, is that right? It is 1:45, so it's been a pleasure being with you, and now comes the question and answer, so pepper me all you